What are the legal ramifications of the McRaney versus North American Mission Board case that has now been decided by the U.S. Fifth Circuit Court of Appeals? It's a question that many Southern Baptists are wondering because of their concerns about autonomy and the case being argued about religious liberty and some of their concerns about how now autonomy looks like it may be skewed one way or the other. And there's quite a bit of debate about this. And so today we have joining us a constitutional attorney, one that deals with constitutions and nonprofit work with churches and organizations, not necessarily Southern Baptist always, but various organizations across the country. Joining me today is Jon Whitehead. Jon, we are delighted to have you joining us.
Good to be here, Bobby.
Jon has been involved with Southern Baptist work all of his life. His dad was a lawyer for representing the ERLC, has a long history there. He also had been a trustee for the ERLC for a period of time, and then has also worked at the national level, helping in the SBC annual meeting, order of business, things of that sort over the years. And so he is very well versed in Southern Baptist life, Southern Baptist history. And so he has kept track of exactly what's been going on with this case for the 9 years that it has been in the court system at this point. Jon, why don't you kind of give us a quick summary real fast of what you see has taken place at this point and where we are?
Well, as probably your listeners will know, the McRaney case involved Will McRaney, who was the former executive director of the Maryland-Delaware Convention. And McRaney alleges that NAMB and NAMB executives decided that he was an obstacle to goals they wanted to achieve in the Baltimore or in the Maryland Convention, and in essence used blackmail, approached the convention and said, if you don't fire McRaney and replace him with somebody that we like, who's more agreeable to our goals, then we're going to cut off all of the funding under what are called SPA agreements, participation agreements. It used to be that conventions and state conventions and the national entities had to reach agreement about what to do in their borders. But then after 2010, NAMB said it could decide what it wanted to do inside individual states. And if those states weren't cooperative enough, they could just jerk that money. No matter, even if it affected their budgets, they could jerk that money. And so as a matter of Baptist polity, that raised lots of questions. The National Convention had long denied that it had the ability to affect the budgets of state conventions or would exercise any authority over state conventions. So that raised a lot of interesting Baptist polity questions.
Well, and let me interject real fast here. Part of the reason was because these were jointly agreed upon expenditures of money that was coming back. And in this particular case, the Maryland-Delaware Convention actually gave more to the cooperative program and what ended up going to the North American Mission Board than they were receiving back. But part of that money, over $1 million, was used as leverage as such in this agreement. But, you use the acronym SPA, Baptist as bad as the military with our abbreviations, but strategic partnership agreement, or what used to be called cooperative agreements, is what we're referring to at this point. But the reality is the agreements there are mutually agreed upon as far as expenditures and the leverage that North American Mission Board was on the convention as far as his termination. But this case before the U.S. Fifth Circuit Court does not have those facts. That's kind of how it started because of the things that happened not only then, but after he left the convention there, their pursuit of him, trying to keep him from being able to speak, be in other positions, that kind of thing. But none of those cases of the fact actually made it to court. And tell us why those facts never were entered into the court arguments.
Yeah. So, just to wrap up the fact description, the interesting part for a lot of folks is not McRaney's claim that there was a dispute about leadership, but that what NAMB said and did in order to get him either out of his position in Maryland and Baltimore, or Maryland to Delaware, or to, in essence, deprive him of other speaking opportunities or participation in other Southern Baptist events and in local churches, including calling them. And the allegations, McRaney says, are that NAMB didn't just call him a bad Baptist or not a servant leader or whatever it might be, a doctrinal dispute, but made specific allegations about him not attending meetings or not performing contracts correctly or not giving required notices. Then McRaney says, I can prove I did all those things. My performance was not the issue. And yet you've called other Baptist groups not part of this agreement, separate from the convention entities or the state convention entities, local churches, other Baptist associations, and you've told them, you made misrepresentations to them about my performance to kind of make sure they don't, that makes it difficult for me to earn my living. So those are the two kinds of, the two broad areas of dispute. Like you said, the court ultimately reaches the Fifth Circuit's most recent opinion, ultimately doesn't address the question of whether McRaney was right about the Baptist issues, the impropriety of holding the money hostage, or the secular statements about wrongdoing. The court gets there, and I guess I will say that the court does say it reaches enough of a merit decision. It reaches the merits insofar as it says, we've determined this is an internal governance matter, that even McRaney's complaints about communication to those not part of the agreement, not connected by cooperation agreement, you're just somehow in a big Baptist family, even those are considered or were treated under internal church governance, the internal church governance prong of the church autonomy doctrine under the First Amendment. So the court says we looked at the facts long enough to know this looks like a religious dispute to us, and so we're not going to touch it. And even on the secular defamation claims, the court kind of pulls a little move and says, well, he might allege secular defamation, but we've looked at some of the testimony about his damages, and those people are religious people, and they make religious comments in their testimony. And so we don't think he can prove those damages without religious testimony either. I think that's not the way most cases come out if you're not tidying this up. I think some states would award you even nominal damages. If you can prove the facts, you would get at least $1 or $10 or something, some judgment in your favor. And the court says, no, because it was pastors and they made references to how they related to NAMB, that makes this all a religious dispute. And so we're not going to address that claim either. So the merits of what McRaney alleges is either a Baptist wrong or a secular wrong. Those weren't decided. The court decided that NAMB had proved the merits of its defense based in church autonomy, and therefore the court said it won't allow this kind of suit to go forward. And that then means this covers all the courts, all the states in the Fifth Circuit in the cases that might be brought in those areas. And that's most of the South, a significant chunk of the South at this point.
Yeah, it sure is. Well, one of the big contentions for a lot of folks has been the way this argument for religious liberty was argued repeatedly. Now, this has been in the court for 9 years. Went to the Northern District in Mississippi is where it was first brought to the court. Ended up being kicked to the U.S. Fifth Circuit Court the first time. There was a judgment there, and then it was appealed to the en blanc, which is the full court, if I'm describing that correct, which was 9 justices, not just 3. They received a decision in favor of McRaney at that point, a 5-4 decision, I believe was right at that point. And then NAMB took it to the Supreme Court and asked for it to be heard there. It was denied, came back down to the lower court, which is Northern District, Mississippi. Again, everything was in place for a jury trial. The date was set. To be clear, and they'd take depositions of all the key players that were involved. A lot of testimony had been put in the documents and submitted to the courts, the various courts at different times. And about 10 days, 2 weeks, something like that, it was pretty close to the trial date. The judge there, in that case, he decided to do a bench decision. I think that's what it's called, a bench decision in which he ruled in favor then of the North American Mission Board. McRaney appealed that to the U.S. Fifth Circuit Court for basically the third hearing at that point, and that's when it ruled against him 2-1 at that point, and they appealed that to the U.S. Supreme Court to be heard, and that was denied. That's why it stands at this point. What people are concerned about in great concern among many in Baptist circles is some of the arguments that were made in the court as they were doing that. So talk to us a little bit about this approach that was made at that point. I want to look at this real quick. There we go. These are some of the things that were assumed in the court arguments by the North American Mission Board. And then you clarify for us, their arguments inferred that SBC ordains ministers. A state convention employee is considered an SBC employee. We are the Southern Baptist Church, they use repeatedly in multiple court filings. They referred to themselves as the SBC Mission Board. Of course, we know we have the International Mission Board, which is obviously funded at a much higher level than NAMB, but they use that phrase multiple times. And then finally, they claimed the state convention was a SBC entity. Give us some perspective. Why did they use this kind of phrasing and phraseology? What's your perspective on that?
Yeah, I mean, I think NAMB would say ultimately the court was clear about Baptist autonomy and said that didn't matter. But I think it did matter in this sense. The argument that really swayed the court was one. There was some idea that, well, are you saying the church autonomy doctrine cannot apply to autonomous organizations? And that's not true. If autonomous churches enter agreements together to be judged by each other, then of course the church autonomy doctrine, they can enter agreements that allow them to be to judge each other and to have internal governance over each other. They are free to avail themselves of church autonomy. The real issue here, though, is the court imposing a view of church autonomy and what's internal to the big Baptist family, in essence. And the argument that had the most purchase with the court on that subject was, well, judge the Catholics. They're one big family, and they can talk to each other about their ministers because they're all under the same umbrella. And so if it's good for the Catholics, then certainly you let us treat the big Baptist disputes inside the Baptist family. And so the question becomes, well, who decides who's in the Baptist family? And I would argue, well, you'd have to look at their agreements to know who's inside the big Baptist family. If they've agreed to be in a family, then that's one thing. But if they've entered agreements and specifically said, but we retain our autonomy, or there's lots of statements of the record that we don't control each other, we will never exercise control over each other, then that's a sign they don't want to be in that internal governance relationship. The court, however, said, well, that would be discrimination if we let the Catholics come out different than the Baptists. And in some ways, I think NAMB leaned into that feeling by making, unclear statements about what it means to be an SBC church. As you know, churches cooperate, they don't join the SBC.
Correct.
What's it mean?
SBC has no membership. Correct.
Right. What's it mean to be a state convention? That does not mean that there's the national level that oversees the state level, that oversees the local level. That's hierarchy. We don't want that. And I guess some Baptist group could try to impose hierarchy on themselves, but as a practical matter, these were not agreements among one big church family. These should have been considered as agreements between separate churches or separate faiths. It's much closer to an interfaith agreement or ecumenical agreement. It's as separate as the Episcopalians and the Presbyterians in some kind of cooperation, or even the Mormons and the Catholics, two totally different faiths. They might cooperate on humanitarian grounds. They might have religious purposes in that cooperation, but that doesn't mean that when Catholics and Mormons cooperate, that priests should judge stake officials or Mormon officials should judge priests. That's not what they would have wanted. They would have not have wanted to imply that there was some kind of internal church court system that was going to address the disputes between those cooperating groups. So I think the faulty assumption was that autonomous churches with a similar faith, whenever they cooperate, are assuming some kind of internal governance relationship. That makes sense in a world in which you want to impose that on yourselves. But there are lots of good reasons that Baptists and non-denominational churches and whatever other churches that might cooperate with other faiths, across faiths, that isn't a necessary implication of their cooperation. But the idea that this was a kind of all one big Baptist family dispute and should be treated like a dispute amongst Catholics, that really had purchase with the courts, both in McRaney and in Garner, a similar case pending in Tennessee. And so they said, we're not going to engage in discrimination and we're not going to go that far and find that these are autonomous groups. And therefore, we have to look at what they've actually agreed to. And so I think that really is the error in the McRaney case, is this assumption that just because the Catholics might turn out one way, it should turn out for the Baptists. We both have the same First Amendment, but we're structured differently. We have different beliefs, and the assumptions of Baptist leaders are not the same as the assumptions of Catholics, and especially not the assumptions of local churches are not the same as Catholic parishes or parish priests. Right. So those relationships are kind of made a hash by folding it all under the same idea that, well, it's a big church internal dispute.
Well, and it seems to me that, and I'm not a lawyer, but this is just from an outside lifelong Southern Baptist, the makeup of the courts that this went before, the judges and justices that were there all have hierarchy, high church backgrounds, Catholic, Episcopal, that kind of thing. In the Northern District, I believe that judge was a United Methodist. So it seems like their arguments, meaning NAMB's arguments, use phraseology and language that would hit subliminally on all of those as they're evaluating, looking, and reading that, because they fully understand what it means to be Catholic or Episcopal or Methodist in that hierarchical structure. And even though it wasn't said necessarily, I'm taking this from my Catholic perspective, everybody has their own, belief system and their internal working, the way they think through things and process that. And so I just kind of thought that had something to do with the way they were arguing, and their attorney said, this is how we need to argue to try to make it appear that we're all under this one big umbrella. In fact, they use that terminology in the U.S. Fifth Circuit Court when the ERLC first sent that amicus brief, and they use the term hierarchy and use the term umbrella, meaning, NAMB was an umbrella type organization. Eventually, ERLC went back and made a statement, I think submitted a letter to the court too, to withdraw that. But by then the damage had been done. The damage was done, and that still remains in the court because it has set precedent. Well, tell me this, Jon. Now that the Fifth Circuit Court decision stands, what legally changed for SBC affiliated organizations?
Well, I mean, I think you have to live with the idea that the current rule inside the Fifth Circuit is that whenever you cooperate whenever two Baptist organizations cooperate, or whenever you join a Baptist organization that cooperates with another Baptist organization, the current rule in the Fifth Circuit is that if there's a dispute about ministry leadership or ministry qualification, even though the group has no authority, independent authority to remove that minister.
Right.
That it is Katie bar the door on what the outside group can say about the members and leaders of the other. That even if there's secular defamation, the courts say we're not going to hear that case as a matter of internal governance under the constitutional principles we've decided. And it may be the Fifth Circuit didn't quite reach this question. I've seen some scholars, though, argue that this is a structural constitutional doctrine. And so that means that however the courts define it, Baptists can't waive out of it. They couldn't have an agreement that says we don't want to use that rule. We want to use the rule Baptists have always used. So you need to understand that whenever you cooperate now, whether it's giving through Lottie Moon, whether it's cooperative program money, whether it's entering a spa, there is this legal rule in the Fifth Circuit that the leaders of the other really don't have any legal limits. They can't be hauled in front of courts, at least, about what they do, even if it rises to the level of secular defamation, even if it's misrepresentations, not about your Baptist doctrine, but about what you're actually, facts that a normal jury could hear. So your cooperation, in this case, the court now says implies you've given up civil remedies that most of you would have. And when you cooperate with other Baptists, if two Baptist businessmen enter an agreement, nobody would make that assumption. So it is a trap for the unwary that when you enter these agreements, you need to be pretty clear that there's not a scoundrel on the other side that doesn't go rogue and defame you, because if they do, there's not going to be a civil court remedy. Now, NAMB would say, well, you can always take it to the church. And I'm not sure that's right. We'll see how that plays out, is my guess,
right,
in some future case, because the courts can't make some independent Baptist organization submit to a local church decision. All the judicial authority in Southern Baptist life is in local churches. And so if First Baptist Prairie Prairie says McRaney was defamed and NAMB owes him $1 million, NAMB is not going to submit to that local church decision. Right. And even if they did, a court is not going to make NAMB pay that money. And even in the middle of the process, you won't have the advantage of subpoenas to get witnesses to testify or subpoenas to get documents you might need to prove your case. So at best, it forces Baptists to form courts they didn't want, that can't do the job as well. And at worst, it's going to leave you without a remedy. This side of heaven, it's going to leave you without a civil remedy.
A precedent's been set, is what
right,
you're saying.
Right. And so you face a extreme uphill battle if you are in partnership with folks that decide they need to lie about you to get you out of your position.
Yeah, I think I know the answer to this, but did this ruling expand or diminish church autonomy protections beyond the historic limits?
Yes, and both. It expanded it for leaders, expanded it for groups that normally you would have said, well, they're outside my church. They've got no authority over me. And so when I joined my local Baptist church, that shouldn't mean anything about Kevin Ezell or NAMB or some Baptist executives' right to lie about me. So it protects the leaders of cooperating groups that want to go to the mat to get people gone. It removes the civil law protections from individual Baptists and smaller organizations. As I said in my article at CBL, it's in essence the Thunderdome. There are no rules. Might makes right. Only one will leave if they decide that's the case. And so you're in a dangerous spot. Your cooperation now has new risks that most of us didn't think about in making these cooperative agreements.
Yeah, well, we've linked your articles that you wrote about this in the video description so people can go there and look at it. Let me ask this. Where is the legal boundary now between protected religious speech and actionable false statements?
Yeah, so I mean, I think the rule of McRaney is that whenever there are cooperating religious organizations of any kind, but if their purpose for cooperation is religious, then there is no court remedy for any defamatory statement, whether it's doctrinal. And you know, to some degree, we've always accepted they could lie about you being a liberal, they could lie about you doing baptism wrong. That's a matter for Baptists to decide. Courts could never have decided that. But the new twist is for any cooperating group now, secular torts are okay, or at least not. You can't bring them before civil court. Can't get a jury to decide those facts. Can't use the government process you normally would. If the defamations are related in some way to that ministry dispute. Remember, McRaney, he was already gone as a leader. They just didn't want him to even speak at a Baptist event at another church. So that kind of defamation as well. That's the reach of when you join with Baptist groups that partner with other Baptist groups. And so it's not limited to the parties that actually make the agreements. It includes their leaders as well, and perhaps their members, is the argument being made in Garner, in Tennessee. But there's a fairly wide swath of people that when Baptist organizations cooperate, when any religious organizations cooperate, they lose their civil court remedies that they otherwise would have had. And normally, courts would require pretty strong evidence of consent or submission to a religious authority before they would let them exert that kind of authority over them. And the Fifth Circuit says, the topic here is a substitute for what we're going to allow to be waived.
You know, most pastors that I know, and ministers, and most church members, I would guess, but at least among pastors, they're pretty risk averse. They don't want to do things that are going to intentionally put the church at risk, liability, in other words. And of course, we carry insurance, other kinds of things because of liability issues, whether it be a wiggly rail on the front porch steps or something else. Churches are pretty risk averse, and pastors are too, which makes me think, does this decision now create a risk, a higher risk for autonomous churches, associations, state conventions?
Yeah, in the sense that there are wrongs that now can be done to you that you don't have civil recourse for, and that frankly you don't have good religious recourse for. Again, Baptists don't have courts. They don't want courts outside local churches. They don't want some kind of Baptist Supreme Court where all of the convention disputes are heard. Nor
right, that would have to be a hierarchical kind of a structure if you do that, right?
Exactly. You are creating spiritual authority outside and above your local church, which is exactly what Baptist said they were not going to do.
Right.
And so I think in some ways, some folks have said, well, we just need to create our own internal court. That's not what we do. We have good reasons not to let outside hierarchy judge the character and content and actions of each of our local churches. Now, this narrow area of do we cooperate or not, I agree. There's good religious reasons. The First Amendment should in some ways protect truthful communication about legitimate concerns about ministry. That I don't have a problem with. I do have the problem that even if I could prove a secular tort, a secular lie that a jury would understand is wrong, and it doesn't involve a religious question, even that now gets sucked into this doctrine of internal governance. And so it really imposes on Baptist theology in ways I don't think Baptists would have ever chosen themselves. And so that's an example. The courts, in essence, by judicially defining now this doctrine in a way that expands over autonomous groups in this way, really deprives them of the authority, the autonomy, the independence to define their relationships how they want to. We didn't have courts, and there was always the backstop of civil courts if we couldn't settle our disputes. And now we've been told, well, you really need to form some kind of Baptist court to settle all this stuff. And I don't think we want to do that either.
No. No, not at all. Um, so could this legal precedent, which has now been established, discourage transparency of our SBC entities? There's already all kinds of upheaval about lack of transparency and the lack of sharing information, which historically had been shared about planters and missionaries and all kinds of other things that now have not been done. So, do you think this precedent is going to prevent additional transparency or the potential of that?
It certainly gives a foothold for sinful people to engage in really sinful, harmful conduct that they didn't have before. And I want to stress our leaders are no more or less sinful than our local church members, right?
Yeah.
They have the same spiritual authority as everybody, and I would extend them the same presumption of grace and honesty that I would extend to any fellow Southern Baptist. But it does happen that some scoundrels have made it into office before. The Baptists think of the Carnes defalcation back in the 20s, where the Home Mission Board got robbed of $1 million by its treasurer. And even recently, we've had to remove a committee member of the SBC when they were charged with sexual abuse. So it happens. And so the question is, what power do you want to give that person, that foothold, when there's somebody that sin has a foothold in? What power do you want to give them to defame local churches, to protect themselves, to hide from transparency? What tools do you want to give them? And I really don't like the idea that somehow we had to give them the tool of defamation, that if Baptists ask questions or disagree with their policy, then some SBC entity leader or committee member or whoever it would be can then go tell lies about you and wreck your character and make it so that you're treated as a pariah in your local community in order to hide their wrongdoing. That there was a good reason we didn't let that happen in the past, and I think it's probably a bad sign that this rule in essence gives them that power now.
Well, we mentioned a while ago about liability, both upward and downward, I guess you could say. But does this now expose local churches where they're going to face expanded liability issues potentially? I mean, I had one pastor, just real quickly, but one pastor said to me, he was, I believe, in New Mexico at this time. And he said, man, if there's been an abuse case, situation at some church on the other side of the country, he said, could I now be sued because we also are giving to the cooperative program and that church is a part of or an SBC affiliated church? They're not a member, as we stated, but they're affiliated with the SBC. Now, has this created a connectionalism where I could actually be sued for something that another church has done, or even closer to home within my own association, because we're both in that association? Could they connect that to me legally now? What's the exposure for us?
I mean, as I said in my article in CBL, I do think it will be hard to buy only one side of the coin of we're all one big family, right? And so if the court deals with in a case against the convention and churches, local churches, it will be all too easy, all too foreseeable that some judge that doesn't support the convention will then say, well, look, y'all said you're one big family over here, and you said that was discrimination to treat you as not all having internal governance over each other. And so if you had internal governance then over there, then of course, for purposes of liability, you also share internal governance. Now, that's going to be a battle royale. There's going to be lots of arguments and lots of lawyers that end up fighting that argument. But does it create the risk of that? It certainly increases the risk in my mind that when we buy one side of the coin of internal governance that benefits us, then at the point it hurts us, it's going to be fed back against us. And so, the Fifth Circuit, the way it deals with church autonomy to say, well, you can have any polity you want as long as it's Catholic, and we'll treat it like Catholic polity. It's like Henry Ford. You can have any car you want as long as it's black. Well, that's not real autonomy, right?
Yeah, right.
That's the illusion of choice. If when you go to the courts, they treat it all as like the hierarchy. And so I think we are in a dangerous legal position. Somebody's going to have to nail that down. That then have we also bought ourselves internal governance over each other when it comes to secular matters that can make it to courts from outsiders facing in? That will be something to see.
It kind of reminds me of the old parenting advice when your child is giving you a hard time, to give them two options to choose from that are acceptable to you.
Right.
Therefore, they choose either one. You're
Right.
okay with it, and they think, "Hey, I've got control. I've got power."
Right.
And that's not really the case.
Right.
The kid is making the decision for themselves, independently. Is another word you could say.
Yeah, I've seen folks on X saying, "Look at how strongly they recognize Baptist autonomy," and that's true. Except that then they go on to say, "But it doesn't really make a difference. It's the same rules going to apply." And so, congratulations, you have the illusion to choose whatever autonomy you want amongst yourselves, but in the courts, it's going to be the same rule for everybody, all cooperating religious groups, regardless of their beliefs or structure or what they opt into. And so that's, as I've said, I think is a short-sighted argument. I think it'll be hard to avoid the impression.
Yeah. Well, I've got one more question for you, but before we do, I kind of put together some potential next steps. One of the things I've heard from a number of churches, and spoke to about 4 or 5 different pastors yesterday, that told me this is one of the reasons why our church voted to pull out of the Southern Baptist Convention. Some of them are still active in their local association and with maybe even their state convention, but they didn't want any connection to the other entities, particularly NAMB in this case. But without just pulling out of the SBC, what are the other possibilities of things that could, be helpful? And I was looking at this, and these are a couple of things that I wrote down that could potentially be, those are the assumptions we had a while ago. The next steps. Churches can file their own 501c3 nonprofit paperwork instead of falling under their state convention's 501c3. Contact their state's NAMB trustees and express their concerns about this. Be sure to have a clear statement in your own bylaws, your constitution and bylaws, that's establishing your autonomy as governing independence. In other words, you govern yourself, no one else does, and that no other organization has the authoritative control over your congregation. Every church I've helped over the years to try to write their own constitution and bylaws, I've made sure they had something in their documents that said, we are self-governing. No other organization governs us. State conventions, I've helped write constitution and bylaws. Associations, I've helped do the same thing. And every one of them says, we have no authoritative control over churches or other SBC related or affiliated organizations.
Mm-hmm.
What can you add to that? And is there something else you would say?
Yeah, well, some of that's was good governance anyways. I've been telling churches and conventions, frankly, they don't want to be using that one big group letter. Some of them do. Some of them say, well, we can all be under one group exemption letter. And the IRS has been looking at changing those rules for a number of years anyways, to imply control or require control. And so, ahead of that, I just think you don't have to get a letter of your own, frankly. You can rely on the IRS rulings there. But if you're going to have a letter, you need a letter, go ahead and get your own letter. That was good governance before and after. I think all the other steps you mentioned are correct steps. I think for now, I'm going to assume that if there are explicit agreements on these matters, if it's in the contract that, we're going to be judged as completely separate churches with no authority over each other and don't want, these rules to apply to us, I'm going to assume that most courts are going to honor that. As I said, there's this argument in some places that even if you had tried that, the court it still impose the McRaney rule on you. And so you can't contract out of it. But for now, I think the prudent course is, in most places, the courts are going to try to honor the explicit agreements of religious groups about how their conduct should be judged. It means you have to think about it hard, right? You have to think about what if we do have a dispute with our ministry partners? Is that something we would take to Christian arbitration or to peacemakers if we can't get a court ruling? Is that something that we would let our association settle? Is that, how is it? Or does one church submit to the other? How are you going to settle these disputes in any of your partnership arrangements? Because the government's dispute resolution plan isn't favorable to you at this point if there's a dispute. So those are all good steps to take. For right now, I'm going to tell folks, make it clear in the documents you sign. And then, if the court has reason to impose this in the future on a group that didn't agree to it, then we'll see what arguments are made about whether or not you can contract out of this rule.
Okay, let's wrap it up with this. I want to give you the chance to be a foreteller, predicting the future, shall we say, at that point. 5 years from now, will this decision strengthen or strain SBC cooperation?
Yeah, I mean, I think it can't help but strain cooperation. This, at the very minimum, creates uncertainties about how to deal with, in some cases, pretty wild misconduct.
Mm-hmm.
And so, the Baptists are set up to decide what should we do about a fellow church that teaches different than us on baptism or membership or whatever it might be. We've got experience in with that. But the system was never set up to reach intentional wild misconduct that destroys lives and families and careers.
Right.
And so, A, that's just going to create uncertainty. B, I do think, look, there are 5,000 or 10,000 maybe individuals involved in governing Baptist groups at various stages in the state conventions and in local churches. And I don't know where there's a scoundrel. I can just tell you there is a scoundrel. Somebody's going to take advantage of this rule in a way that's pretty horrific. And so that will create uncertainty. And whenever you can't trust the other side, and whenever you think they might have an incentive to act badly that you can't get rid of, that imposes costs on agreements. That makes them, in essence, more expensive, the economists would say. And so does Baptist cooperation cease? No. Does the convention crumble overnight? No. Does it weigh down our cooperation? Does it make it heavier? Does it make it more burdensome? Does it make us spend more time hammering out dispute resolution agreements and handling disputes that we wouldn't have in the past? Probably so. Now, the magnitude of that cost that gets imposed, I don't know. We'll see, especially, like I said, there's similar arguments in a case in Tennessee, and we'll see how that gets applied there. And that will tell us if the courts are inclined to read McRaney broadly in the ways that might have lots of the negative effects, or if the courts are going to try to cabin it in a little bit or make distinctions so that McRaney ends up kind of the high water outlier amongst cases. We'll just have to see how that goes. And courts are slow, so I think there'll be a number of years of uncertainty that we do pay, lawyers and dispute resolution and spend more time negotiate with each other because we just haven't planned for this rule in the past.
Yeah. Well, Jon, I know we haven't been able to answer all of the questions, and there's a lot of question marks people still have, I know, especially about what this is going to look like down the road. But I appreciate you coming and giving us your thoughts and your opinion from a legal standpoint to try to help us understand a little bit more about the kind of footing that we have. Thank you for joining us today.
It's good to be here, Bobby. Thanks for having me.
Well, we are grateful for Jon and for what he has done to try to help represent Southern Baptists. I want to say that we're going to keep up on this and other SBC issues, and we'll try to keep you posted on that as well. Thank you again for joining us today.